Hello and welcome to the Shifting the Paradigm webinar series, where we build community knowledge, skills, confidence and understanding of child sexual exploitation. We hope that you find this webinar beneficial.
I'm Jodie Griffiths Cook, and I've been both the Public Advocate and the Children and Young People Commissioner for the ACT, or if there are any international attendees, the Australian Capital Territory, for over 9 years now. I commenced these two roles in early 2016 when they were brought together under the newly reformed ACT Human Rights Commission. Notably, despite the Children and Young People reference in my title, I also have responsibilities that extend to include adults. But more about my role later. Before I begin, I wish to acknowledge the traditional custodians of the lands from which I'm speaking to you today, the Ngunnawal and Ngambri peoples, as well as those First Nations peoples whose custodianship continues to nurture the lands on which each of you are based. I pay my respects to elders, past and present, and also acknowledge the emerging leadership capacity of First Nations children and young people, recognising the importance of culture in giving their lives strength and meaning. Notably, given today's subject, I also wish to reflect on the significant overrepresentation of Aboriginal and Torres Strait Islander children and young people in those systems that, while well-meaning, continue to disconnect them from culture and perpetuate intergenerational trauma. Each of us here today have a role to play, indeed a responsibility to address the root cause issues that contribute to this overrepresentation, something that I consider sufficiently important to remind myself and all of you about when speaking about troubling issues such as child sexual exploitation. Thank you for taking the time to be here for a conversation that is both incredibly important and undeniably difficult. I know simply by the fact that you are attending that all of you are deeply committed to making a difference and improving outcomes in the lives of children and young people. As always, it is a privilege to speak to such a dedicated group of people. The work we do is invaluable, but as we all know, the challenges we face in protecting children and young people from harm can be overwhelming. However, we also know that the road to real change, real protection for children and young people is not an easy one. It requires both knowledge and action. So today we're going to talk about an important but often overlooked topic: children's rights and their relevance to child sexual exploitation. But before we begin, I want to acknowledge that this topic can be distressing. Child sexual exploitation involves the abuse and betrayal of trust against children and young people, and it can raise strong emotional responses. Please take care of yourselves throughout this webinar. Step out if you need to. Face it, I won't even know. Reach out to someone you trust and be mindful of how this affects you personally and professionally. The importance of looking after ourselves when we work with confronting issues such as these should never be underestimated. Conversations about child sexual exploitation can feel uncomfortable at times, especially when we frame it within a children's rights context. Because the truth is that children's rights are often an afterthought in many professional settings. And child sexual exploitation, while widely recognised as a critical issue, continues to be vastly underreported and underaddressed. As professionals, we are in a unique position to change that if we understand the issues clearly and take action. While recognising that child sexual exploitation is a key focus for some of you, for those who may not be familiar with the term, child sexual exploitation, often abbreviated to CSE, is a form of abuse where a child or young person under 18 years old is manipulated, coerced, or forced into sexual activity by a person or a group, often in exchange for something the child or young person needs or wants: money, food, shelter, protection, or even affection, and always to meet the needs of the perpetrator. Sometimes it is done by strangers, but it may also be someone the child or young person knows, trusts, or depends upon. And in today's digital world, exploitation doesn't always happen in person. It happens online, in chat rooms, through social media, gaming platforms, and in private messaging apps. Children and young people are being groomed, manipulated, recorded, and exploited by people they have never met face to face. Children and young people may not even recognise they're being exploited. In fact, often they don't. And this can make detection and intervention even more complex. Notably, it doesn't always involve force. It's about grooming, coercion, manipulation, and the exploitation of vulnerability. And it happens across all communities, cultures, and socioeconomic circumstances. Let's begin with the foundational concept of children's rights. Children's rights refer to the basic human rights that all children and young people, regardless of nationality or circumstances, are entitled to. To understand how best to respond to child sexual exploitation, we must begin by grounding ourselves in children's rights. The United Nations Convention on the Rights of the Child is the most widely ratified human rights treaty in the world. Nearly every country in the world has signed on. It sets out the civil, political, economic, social, and cultural rights that every child, every human under the age of 18 years is entitled to. The Convention is a legally binding international document and outlines the minimum standards for the protection, care, and development of children and young people that all signatories to the Convention must uphold and embed through domestic application and through their engagement across international borders. At its core, the Convention recognises that children and young people are vulnerable and that they need special protection to ensure that they can grow, develop, and live their lives free from harm. Children's rights are therefore essential for their survival, development, and well-being. When we talk about children's rights, we're talking about the basic inherent entitlements that ensure children and young people are protected from harm, are provided opportunities to thrive, and have the ability to influence decisions that impact their lives. However, the Convention also recognises that children and young people are not and should never be considered passive recipients of care. They are individuals with their own rights to be protected, to be heard, to grow, and to thrive. Every response to child sexual exploitation, whether from police, educators, health workers, social workers, or policymakers, must be guided by these rights. The rights enshrined in the Convention are non-negotiable. They are intended to protect children and young people from abuse, neglect, and exploitation. However, as we know, child exploitation is one of the most severe violations of these rights, particularly the rights to protection, the right to safety, and the right to dignity. Child sexual exploitation can take many forms, including grooming, trafficking, pornography, and prostitution. As previously stated, children and young people who are sexually exploited are often coerced or manipulated into these situations. The perpetrators take advantage of a child or young person's vulnerability, often through deceit, manipulation, or force. What is particularly troubling is that the majority of children and young people who are exploited do not see themselves as victims. And this is why it is so crucial that professionals like us understand children's rights and how violations such as child sexual exploitation undermine those rights. As we discuss children's rights today, it is essential to understand that the responsibility for upholding those rights does not fall solely on us as individuals or on the organisations that we might belong to. Governments have a central role to play. When countries ratify the United Nations Convention on the Rights of the Child, they are making a binding commitment to ensure that the rights of children and young people within their borders are fully protected and upheld. The Convention provides a comprehensive framework that governments must follow if they are to guarantee the well-being, safety, and dignity of each and every child and young person who is a citizen of their country. The responsibilities of government are multiple, but at minimum they include legislation. Governments must pass and enforce laws that align with the Convention. This means creating legal protections against abuse, exploitation and discrimination, and ensuring that the views of children and young people are heard and considered when making decisions that affect them, not just individually, but collectively at systems levels as well. Implementation and enforcement. It's not enough to simply enact laws. Governments must ensure these laws are actually put into practice, including by providing adequate resources to agencies that protect children and young people, such as social services, law enforcement, and educational systems. These systems cannot do and uphold the responsibilities they are charged for without the resources necessary to do so. Monitoring and reporting. Governments are also required to regularly report to the United Nations Committee on the Rights of the Child on the progress they've made or are making in upholding the Convention. This ensures accountability and encourages continuous reflection and improvement in activities that protect children and young people and uphold their rights. International cooperation. The Convention also encourages countries to collaborate with one another, particularly in the fight against issues like child trafficking, child labour, and child sexual exploitation. This means that governments must work together to create international safeguards and responses that protect children and young people. Governments must not only prevent violations of children's rights, but also ensure that any breaches are addressed promptly. Ultimately, it is their responsibility to create an environment where all children and young people can enjoy the rights to which they are entitled, to be safe, healthy, educated, able to participate fully in society, and importantly, to be protected. The Convention also offers a comprehensive framework for understanding and addressing child sexual exploitation. It reminds us that child sexual exploitation is not just a crime. It is a violation of a child's or young person's intrinsic human rights. Understanding the Convention helps us move beyond reactive, incident-based responses and instead promote child-centred, rights-based approaches to prevention, early intervention and support. While there are many general articles within the Convention that have broader relevance to the issue of child sexual exploitation, for example, the right to health, the right to education, let's now explore some of the key articles from the Convention that are particularly relevant to this issue. I might just take a brief drink. One of the core principles of the Convention on the Rights of the Child is the concept of the best interests of the child. This principle is enshrined in Article 3 of the Convention, the first part of which states, "In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration." While a standalone article, this article is also all-encompassing, requiring all other articles to be read and implemented within this context. What this means is that whenever decisions are made that affect children and young people, whether it's related to education, healthcare, family life, or even legal proceedings, the child's or young person's best interests must be at the centre of those decisions. This principle is not just about protecting children and young people from harm. It is about actively promoting their well-being, their development, and their opportunities for future success. It means ensuring that children and young people are treated with dignity and that they are given respect in every aspect of their lives. Equally, it requires that their needs, including emotional, psychological, and physical safety, are prioritised above all else. In practical terms, this means that decisions affecting children and young people should take into account their opinions, the context of their family or community, and their long-term welfare. Taking a child-centred approach to decision-making seeks to ensure that children and young people grow up in an environment where their rights are upheld and their potential is fully realised. Acting in the best interests of a child or young person is a provision embedded in most, if not all, domestic legislation relating to children's rights, safety and well-being. Notably, it's a primary consideration within the legislation relevant to child protection in the ACT. But what does this mean in practice when it comes to child sexual exploitation? It means that we cannot make decisions based solely on what's easiest, quickest, or most resource efficient. Instead, we must take the time to understand what is truly in the child's or young person's best interests, which may involve navigating difficult or conflicting perspectives, including the child's or young person's wishes, their safety, their need for stability, and the importance of healing and support. Sometimes systems inadvertently prioritise adult convenience or institutional risk over the needs of children and young people. For example, returning a child or a young person to a home environment that seems safe on paper, but where underlying risk factors remain unaddressed. A rights-based approach requires a holistic assessment of the child's or young person's situation and the potential for their long-term well-being. As mentioned previously, children and young people have the right to express their views freely about matters that impact them. Article 12 emphasises this right and also states that their opinions must be given due weight according to their age and stage of maturity. This article acknowledges children and young people as individuals with their own thoughts and feelings who are capable of participating in decision-making processes. This right applies in many areas of life, such as family decisions, school matters, legal procedures, and public policies. And while Article 12 doesn't mean that a child's or young person's views will always determine the outcome, it does require that they be heard and seriously considered. The article promotes active participation, ensuring that children and young people are not just passive recipients of adult decision-making. It encourages governments, schools, legal systems and families to create environments where children and young people feel safe and respected when sharing their opinions. Alongside Article 12, Article 14 guarantees children and young people the right to freedom of thought, conscience and religion, and recognises the evolving capacities of children and young people as they grow, develop and mature in their thinking and become more independent. This article supports each child's and young person's personal development and respects their individual identity. Article 14 notes the responsibility of parents and guardians to guide their child or young person's development in ways that respect these evolving capacities. However, other adults also have a role to play in this regard, whether as educators or because they are a trusted adult to a child or young person. While this article provides for freedom of thought and expression, it also makes clear that this freedom must be balanced with respect for the right of others and public safety. As I like to say when I'm speaking with children and young people about their rights, with rights come responsibilities. Together, Articles 12 and 14 of the Convention empower children and young people to participate in society as individuals with their own views and beliefs. They recognise that children and young people are not just future citizens, they are active rights holders in the here and now. These articles aim to ensure that children and young people grow up in environments that respect their dignity, their opinions, and their freedom of belief. They remind us that children and young people are not just passive recipients of decisions made about them, but that they are the experts in their own lives. In the context of child sexual exploitation, this means creating safe spaces where children and young people feel listened to and taken seriously. It means including them in decisions about their care, their recovery, and their future. And it means acknowledging that children's and young people's resilience and insight can be key to their protection, provided the adults around them listen and support them appropriately. It also means resisting the urge to dismiss children's and young people's views and perspectives because they are traumatised, non-compliant, or don't behave how we expect them to. Trauma does not negate insight. We must ensure their participation is real and not tokenistic. Importantly, however, when we're talking about child sexual exploitation, we must remember that no matter their age or how mature they might seem, children and young people cannot consent to exploitation. No matter what they've said, done, or accepted, they are never to blame. The responsibility lies entirely with the adult or adults who exploit them. Having said that, if we are supporting a child or young person who has been or is at risk of child sexual exploitation, it is important that we meet them where they are at and seek to understand how their motivations are influenced by what we know to be exploitation, but what they often consider to be a relationship. When we fail to understand the needs that are being met for the child or young person and do not implement replacement strategies to enable those needs to be met in other ways, we run the risk that the child or young person will either deliberately or inadvertently sabotage our efforts. Regardless, children and young people have the right to have their views heard, and decision-making must be informed by their perspectives, recognising the often tricky balancing act between their participation rights and their right to be protected. Moving on now to the more specific rights to protection that are articulated in the Convention. Article 19 is the overarching provision in terms of the right to protection, and like best interests, needs to underpin how we contextualise and uphold the more specific protective rights that are contained in some of the future articles that I'll speak to shortly, or further articles. Article 19 is one of the most powerful protections in the entire treaty. It states that children and young people have the right to be protected from all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation, including sexual abuse, while in the care of their parents or that of others. It is worth emphasising that this article doesn't say some forms of violence. It says all forms. This means the obligation is broad and proactive. What this also means is that governments, and by extension all of us, have a clear and binding responsibility to take legislative, administrative and educational measures to protect children from harm. Not just when violence or abuse happens, but before it happens, through prevention, early intervention and support systems. Because child sexual exploitation is not always a violent or overt crime. Sometimes it is a slow, insidious process of manipulation, and that makes it all the more dangerous. Article 19 is central to the message we are here talking about today, that every child and young person has the right to grow up safe, respected, and free from harm. In practice, this might include trauma-informed school practices, robust child protection policies in institutions, the implementation of child-safe standards, accessible support services, information written in child-friendly language, and training for frontline staff to spot warning signs early. Now let's take a closer look at some of the other protective articles in the Convention that relate more directly to child sexual exploitation. These articles, 33 to 36, outline the governmental obligations to protect children and young people from specific forms of harm and exploitation. Article 33 of the Convention emphasises the importance of shielding children and young people from the dangers associated with drugs, both in terms of using them and being involved in their production or distribution. In the context of child sexual exploitation, it becomes particularly relevant when substances are used by perpetrators as a means to manipulate, groom, or control young victims. The use of drugs or alcohol can impair a child or young person's judgment and resistance, making them even more vulnerable to abuse and exploitation. While this article focuses on drugs, the underlying principle is that children and young people must be protected from any form of exploitation, including the exploitation of their bodies and minds. In the case of child sexual exploitation, some perpetrators, as we know, use substance abuse as a tool of control, grooming victims through drugs or alcohol to make them more susceptible to abuse. Article 34 is the most direct article in the Convention addressing sexual exploitation and abuse. It includes protection against coercion into sexual acts, involvement in prostitution, and the use of children and young people in pornographic content or performances. The article underscores the obligation of governments and professionals to implement measures that prevent such abuse and highlights the role of education, awareness, and professional training in safeguarding children and young people. Article 35 addresses one of the most serious forms, goes on further to address one of the most serious forms of child sexual exploitation, that of child trafficking. Focusing on one of the gravest forms of exploitation, this article mandates that children and young people be protected from being abducted, sold, or trafficked. These crimes often involve sexual exploitation and are carried out across local, national, and international boundaries. Professionals working with children and young people have a duty to remain alert and to take proactive steps to prevent these crimes and support victims. Equally, government has a responsibility to work not just within the boundaries of its own country, but also across state and territory boundaries, as is the case in Australia, but also international boundaries, to stem the tide of child trafficking and to intervene early to prevent it happening into the future. Lastly, but not least, knowing there are 43 articles, Article 36 acknowledges that children and young people can be vulnerable to a range of exploitative practices, recognises that there are many forms of exploitation beyond those explicitly stated in the previous articles, and calls for the protection of children and young people from all other forms of exploitation. This article is a reminder that child sexual exploitation is just one form of harm. It also includes forced labour, harmful child labour, and other practices that threaten a child's or young person's well-being. The article calls for comprehensive protections and a holistic approach to protecting children and young people from all forms of exploitation across all settings. Together, these articles establish a clear framework of responsibility for governments and other professionals. They also highlight the importance of prevention, early intervention, and coordinated responses to keep children and young people safe from exploitation in all its forms. These articles serve to remind us that exploitation rarely happens in isolation. A child or young person at risk of sexual exploitation may also be using drugs, may be experiencing neglect, may be trafficked between locations, and/or may be vulnerable due to housing instability or past trauma. Professionals need to understand the complex interconnections between these risks. A child or young person may be labelled as choosing risky behaviours, when in reality they are being groomed, coerced, or are trading sex for survival. These articles urge us to look beneath the surface, to respond with care and not with criminalisation. Now let's bring things back to what all of this means at the local level, at least specifically for where my role is situated within the Australian Capital Territory. In 2004, the ACT became the first jurisdiction in Australia to pass a Human Rights Act and remains one of only 3 jurisdictions in Australia to have explicit human rights legislation, the other 2 being Victoria and Queensland. At its core, the ACT Human Rights Act protects a range of civil and political rights, including the right to life, to privacy, to freedom of expression, and to protection from torture and cruel treatment. It also protects the rights of children and young people and ensures a fair trial for all. These aren't just abstract ideals, They are legal standards that public authorities must consider and apply in their day-to-day decision-making. Particularly relevant to our discussion today is Section 11.2, which provides for the right of children and young people to additional protections simply by virtue of being a child. Despite being only a single provision within our Act, Section 11.2 is interpreted beneficially through the lens of the Convention on the Rights of the Child, which means we can draw on all key articles in the Convention when considering whether the rights of children and young people are being adequately upheld. As a human rights jurisdiction here in the ACT, and I should be clear for those who aren't aware that Australia as a federal jurisdiction does not have an explicit Human Rights Act. But as a local human rights jurisdiction in the ACT, whenever government proposes a new law or policy, it must first consider how that law affects people's human rights. It also means that if someone believes their rights have been breached by a hospital, a prison, or a government agency, for example, they have the right to raise that concern and their complaint must be taken seriously. It also means that courts and tribunals in the ACT must interpret laws in ways that are consistent with human rights wherever possible. One of our roles here within the ACT Human Rights Commission is to review and provide comment on new legislation and proposed changes to laws, insofar as those changes bring about human rights considerations. This enables us to consider whether human rights, and in my case, children's rights specifically, are appropriately upheld and reflected in the proposed legislation. Further to this, part of my role as the ACT Public Advocate is to hold systems to account in terms of their public authority obligations under the Human Rights Act. This recognises that while government systems can place limitations on rights in certain circumstances and by law, any such limitation must be reasonable and proportionate and supported by evidence. However, challenges remain. There are gaps in specialised therapeutic responses for children and young people affected by child sexual exploitation, and systems can still sometimes prioritise restrictive behaviour management over understanding trauma. But the ACT's human rights framework provides a powerful tool for advocating for better, more responsive, child-centred care. My role as the ACT Public Advocate is statutorily independent. It's one of 8 independent statutory positions within the ACT Human Rights Commission, albeit that these are held by only 4 office holders. As mentioned previously, I hold 2 of those roles. I'm both the ACT Public Advocate as well as the Children and Young People Commissioner. As the ACT Public Advocate, I'm responsible for protecting and promoting the rights and interests of people whose condition and/or circumstances render them vulnerable to the risk of abuse, neglect, and/or exploitation. This may be because of their age, but may also be because they have some form of disability, impairment, or situation that heightens their vulnerability. As mentioned in my brief introduction, despite the CYPC part of my title, my role as public advocate is not limited to children and young people and extends to include adults as well. While the primary legislation giving authority to my role is the Human Rights Commission Act of 2005, there are also 17 other laws that give the PA powers and/or responsibilities. As you might imagine, there's no shortage of business within my team. Many of these laws require government and other agencies to advise the public advocate about decisions they have made or actions that have been taken or that are proposed to be taken, that were it not for the particular legislation saying these things can be done in certain circumstances, would otherwise represent a breach of rights. Part of my role as public advocate is to review these documents, these notifications, noting that we received over 12,000 last year, to consider whether the evidence provided supports a finding that the decision or action is reasonable and proportionate given the circumstances. And where it isn't, we can intervene in courts and tribunals or via other mechanisms to have these decisions reconsidered or to provide additional information, including about human rights, that should be taken into account by the decision maker, whether in making the original decision or in reviewing a decision that's been previously made. Some of the main systems that we oversight include child safety, youth justice, mental health and forensic mental health, restrictive practice use on children and young people in educational and out-of-home care settings, and protection matters involving people with disability, whether they are adults or children or young people. By far, the vast majority of documents that we receive relate to mental health and forensic mental health, but child safety and youth justice are definitely the next in line. I tend to promote my role as public advocate as being that of a critical friend. In other words, my job as public advocate is about helping systems to be the best they can be by making sure they do what they are supposed to do in the way they're supposed to do it. A key focus for our work is looking for ways to improve outcomes individually and or systemically. We raise concerns early and flag relevant considerations to support informed and ideally improved decision making. If I sit back and wait for things to go wrong, then I'm as much a part of the problem as those people making those decisions. Key to our approach is building trust by focusing on the central point of commonality, that being that we all want a good outcome or solution that upholds people's rights and interests. Despite being a small jurisdiction, child sexual abuse is as much an issue in the ACT as it is anywhere else. Excuse me. I first raised the issue of child sexual exploitation with government in late 2018 when I wrote to the Director General of the then Community Services Directorate due to concerns about a small group of highly vulnerable young women. Notably, when I most recently wrote to the Director General last year about the same issue, at least one of the young women who is the subject of my 2018 correspondence was alleged, now as a young adult, to be grooming younger girls. Someone who had been groomed herself previously had become the groomer. Through my recent correspondence, I advised the Director General about a number of young people known to my office who we believed to be either already caught up by the adult perpetrators or who were at risk of becoming so. Some of these young women were under the care of the Director General, while others were known to the Directorate in other ways, and some were not previously known at all. While we do not yet have a standalone service specifically dedicated to child sexual exploitation, there are a range of services that work together to identify, support, and protect children and young people who may be at risk. However, we are still developing our knowledge and our capacity to do so effectively and in a proactively coordinated way. We often need to rely on what can be a complicated application of multiple laws to protect children and young people who are at risk. Practically, this includes practices such as issuing cease and desist notices and applying for personal protection orders, which can enliven the potential for apprehension of and charges being laid against adult perpetrators. As you may also know, the ACT government has recently demonstrated its commitment to children's rights by raising the minimum age of criminal responsibility to 14 years. The associated changes to the Children and Young People Act that support the raising of the minimum age of criminal responsibility have been framed in a way that brings together opportunities and challenges when it comes to child sexual exploitation. For example, we now have a therapeutic support panel that exists to facilitate alternate service responses for children and young people whose behaviour risks or causes harm to themselves or to others. The legislative amendments also create a new type of civil order, an intensive therapy order, or ITO, that not only provides a response for children and young people whose behaviour would have previously been considered an offence, but also provides a mechanism to respond to children and young people who have engaged in or are at risk of sexually harmful behaviour and who need structured therapeutic intervention within a legal framework. An ITO is a court-ordered therapeutic intervention made under the Children and Young People Act of 2008. It is used in very specific circumstances. For example, when a young person is engaged in or at high risk of behaviours that could lead to significant harm to others or themselves, and where a coordinated intensive response is necessary to protect the child and or others in the community. Intensive therapy orders can mandate a young person's engagement in specialist therapeutic assessment and treatment, be linked with conditions related to living arrangements, education, attendance or supervision, and can be used in conjunction with youth justice supervision, care and protection involvement or both. Importantly, ITOs are not intended to be punitive. They are a protective and rehabilitative measure designed to address the underlying trauma driving the child or young person's behaviour. For children involved in or at risk of child sexual exploitation, an ITO can provide the legal scaffolding needed to ensure consistency in therapeutic care, particularly when there are multiple risks, such as substance abuse, running away, or contact with unsafe adults. Importantly, too, not only can they compel children and young people to engage in certain therapeutic practices, they can also compel services, service agencies and organisations to provide those services to the child or young person. Critical to the success of these changes is the need to challenge the narrative that children and young people whose behaviours harm themselves or others are no longer deserving of protection. In fact, many of these children and young people are trying to survive experiences they have not yet been able to express in words. Their behaviour is how they are communicating this. The use of tools like the Therapeutic Support Panel and intensive therapy orders help to reframe our approach. From blaming behaviour to understanding trauma. From managing risk in isolation to coordinating care. From containment to healing and recovery. These responses reflect a rights-based and child-centred approach, consistent with children's rights principles of protection, rehabilitation and participation. They remind us that even the most complex children and young people are still children, and they are entitled to safety, support, and the chance to heal. But how does all of this translate to practice? The first use of an intensive therapy order, of the intensive therapy order provision, involved a young woman who, despite ongoing concerted efforts by her residential care provider and caseworkers, was repeatedly gravitating to coercive drug use and sexual exploitation by numerous adult men. After having tried cease and desist notices toward these men and personal protection orders to disrupt the perpetrators, and even with some of the men breaching the orders and being charged and incarcerated, the network of perpetrators was sufficient in number and approach to keep the young woman tied to their exploitation. The decision was ultimately made to use the legislative provisions to make an order that confined her to a community location for the purposes of assessment and therapeutic care and treatment, with powers that would enable her to be returned to the place should she leave without permission and begin re-engaging with the adult perpetrators. While I did not oppose the making of the order, I did raise various concerns with both the courts as well as in other settings throughout the implementation of the order and indeed prior to its commencement about what I effectively saw as limiting the rights of a young person in the face of not only her own conduct, but also that of others, over which she had limited, if any, control, and where the limiting of her rights seemed largely due to the insufficiency of levers to adequately disrupt the adult perpetrators. At various times, I also raised concerns about whether the limitation of her rights was reasonable and proportionate, given concerns I had about whether the burden of proof for extension of the order was sufficiently met. At times, I also questioned whether the thresholds for decision-making, especially in terms of making and imposing confinement directions, were sufficiently clear. For example, there were a limited set of circumstances under which a confinement direction could be issued, and while most related to the young person having placed herself in a situation of risk and being unwilling to return to placement, other conditions involved a more subjective determination. For example, that she would be highly likely to go to a listed location. However, perhaps the most concerning of the challenges experienced by the young person during her time under the ITO was her being subjected to additional charges and periods of incarceration in our youth justice facility, in response to her becoming escalated while under confinement in placement and staff not responding in accordance with the approaches laid out in the intensive therapy plan, thereby effectively criminalising the young person for staff failings. A final point of note is the young person's views themselves. She rightly asked on a number of occasions why she was subject to an intensive therapy order when other young people engaging in similar activities were not. This was a legitimate question that underscored the importance of having a robust and defensible framework against which the reasonableness and proportionality of decisions being made and actions taken can be measured. Notably, it was also a question that was never adequately answered. By way of summary, this young person's circumstances before, during, and post-intervention enlivened multiple rights that were not always well upheld nor sufficiently well balanced. In addition to those rights I've already discussed today in working through some of the articles of the Convention, her situation involved deprivation of liberty, Article 37, that required periodic review of her treatment and care, Article 25, and support for recovery and social reintegration, Article 39. My overarching reflection, which is and will guide my approach to the implementation of any future ITOs, is the importance of applying the right levers so as to minimise the burden of responsibility and limitation of rights on children and young people themselves. The focus must always be on disruption of perpetrator behaviours. Every day we have the power to make a difference in the lives of children and young people. When we understand children's rights, we are better equipped to see child sexual exploitation for what it is, a violation of a child's basic human dignity. This isn't just about knowing the theory, it's about recognising that children's rights are crucial to the work you do every day. When you know these rights, you will be in a better position to advocate for children and young people and to respond to situations of exploitation. Think not only about safety, but about dignity, agency, and participation. Consider the whole child or young person, not just their risk factors, but also their strengths and wishes. And advocate for children's rights within your sphere of influence. Whether you're a teacher, nurse, police officer, youth worker, or policymaker, ask how systems and processes can better uphold children's rights. And recognise the signs. Children and young people who are sexually exploited often show signs such as secrecy or withdrawal. It rarely looks like it does in the movies. It might look like truancy, unexplained gifts, self-harm, or defiance. Learn the risk indicators and avoid jumping to conclusions. Understanding these red flags can help you intervene before further harm occurs. If you suspect that a child or young person may be at risk, report it. Every country, and in Australia, every state and territory has its own reporting mechanisms. But the key is to act quickly. Reporting abuse is not just a legal responsibility, it's a moral one. The sooner you act, the sooner a child or young person can be protected. When we take action, we are not just protecting one child. We are helping create a world where all children and young people can grow up free from harm. Foster environments where children and young people feel they can speak openly without fear of judgment. Whether you work in education, healthcare, law enforcement, or social work, always encourage children and young people to express themselves. Listen to what they have to say and believe them when they tell you something. And not just when they disclose, but also in your everyday interactions. Children and young people will often test adults with small disclosures. How we respond determines whether they continue to trust us. If a child or young person discloses abuse, listen carefully and support them. Never blame or shame them. Remember, they are not at fault. Make sure they have access to appropriate supports and don't forget their right to be involved in decision making. You can play a key role in helping them feel empowered at a time when they may otherwise feel powerless. Child sexual exploitation cannot be tackled in isolation. Work alongside social workers, law enforcement, healthcare providers, and other professionals to create a coordinated response to child sexual exploitation. Share information appropriately, build trust between sectors, and keep the child's or young person's views at the centre of your joint decision making. A multidisciplinary approach ensures that children and young people get the support they need at every stage, from identification through to recovery. And remember to look after yourselves and each other. This work is emotionally taxing. Supporting traumatised children and young people can trigger your own stress or past experiences. Regular supervision, debriefing, and self-care are not luxuries, they're necessities. Your role is critical in this fight. Child sexual exploitation is a horrific violation of trust, dignity, and safety. But when we respond through the lens of children's rights, we shift from merely reacting to truly protecting and empowering. We stop asking what's wrong with this child or young person and start asking what's happened to them, what do they need, what do they have a right to, and what do I need to do to facilitate this? I encourage you to take what you have learned today and use it to make a real impact in your communities, workplaces, and beyond. We may not be able to solve every injustice, but each of us can be the one adult who makes a difference in a child's or young person's life. It doesn't take a superhero. It takes someone who listens, someone who notices, and someone who acts. Because when we stand up for children's rights, we're not just protecting the present, we're safeguarding the future.
Thank you for attending this webinar. Please feel free to share our resources and let us know if you have any feedback. If you would like to learn more about our program, visit projectparadigm.com.au and be sure to tune in to the next webinar.